everybody. It's great seeing you all in person. I'm Davita Perry. I'm the managing partner of Schwartz, Perry & Heller. We specialize in representing employees in employment discrimination cases. I am also a proud advisory board member at the NYU Labor and Employment Center. And my sole job responsibility is to keep everybody on track. So without further ado, I want to announce we've got 3 great panels this afternoon. Our first one is on diversity, equity, and inclusion initiatives, legal and policy issues. Our speakers today are Michelle Coyne, Calf McGuire and Margolis, Martin Schmelkin, Schulte Roth and Zabel, and Pearl Zakluski, Kraus and Zakluski. And our commentator is Professor David Sherwin from Cornell University School of Hotel Management. I urge you to read their bios and the materials. They're very, very impressive. And I'm going through it really quickly so that they can get started. So take it away, and I'll see you in a little less than an hour.
I like that comment. In a little less than an hour, stay on time. Thank you, and thanks for everybody. And yeah, following up the general counsel. Oh well, our numbers don't look great, but thanks. First comment is the chairs up here are really a lot more comfortable than out there. So
that's an incentive to be a panelist.
Yeah, it's great to be up here. So we're talking about DE&I, or DE&I&A, as we heard this morning. And as I teach at a business school, and our organizational behavior faculty, our HR faculty, and often the industry that we deal with, DE&I is something that we're talking about all the time. And we've got folks teaching it, and we've got folks practicing it. And as often the only lawyer in the room, I sit there and I'm like, wow, everything you're saying is unlawful. And I'm terrified. And so I'm going to give 2 little anecdotes as and then quickly talk about the law, and then we'll move on. But in January, I was at 2 separate conferences. One, I was at a conference where the general counsel of a publicly traded company said that his bonus and that of those that he supervises was based in part on diversity hires. And I raised my hand and I was like, man, that is so unlawful. And he said, I knew you would say that. And I'm like, cool, because it's true. And then I was at a round table with our head of student placement, and this was in Florida in early January, and she said to a bunch of HR people, well, all of your employees, I'm sure, demand ESG initiatives and DE&I initiatives, and so you have to please those employees by doing all of this. And I'm looking around going, I'm in Florida, and 2 months ago DeSantis won with 65% on a thing, this is where woke goes to die, and he wants to outlaw DE&I, and now we've got somebody at a round table saying all your employees must demand it. And I'm thinking probably half don't, and half go the other way. So we all know the law that after the Civil Rights Act of 1991 and the cases that followed, that for at least Title VII, if sex, race, color, national origin, religion is a motivating factor, it's unlawful. And we've got companies out there saying this is what we're going to do, kind of on a DE&I, and that is exhibit, A, B, and C as to this is motivating. So my first question is, in the higher concept, you've got employers speaking, you've got HR people speaking about this initiative, and as the law stands now, and at the end I'm going to propose a change in the law that would actually make DE&I lawful. We'll get there in a bit, but no one ever listens to what we say when we propose changes in the law, so that's not really going to happen. So we're going to have to live with what the law is for a long time in all likelihood. So I'm going to go to the panel and start asking, but instead of waiting to the last 5 minutes for questions, anyone who has any questions along the way, please raise your hand and we'll just continue on because it's more interactive. But when it comes to questions,
I'm supposed to be the enforcer. They have to be short, of general application, and when we're told that it's sufficient, please sit down.
She said, when we were talking, she was like, yes, we can have questions, but there are rules. So thanks, Pearl.
We're lawyers. We appreciate rules, right?
So, yes. So, starting on the hire concept, you've got a whole bunch of folks talking about things that are scary with regard to Title VII, but you still have clients that want to pursue DE&I initiatives. So, Michelle, we'll start with you. What are you telling your clients to kind of accomplish the goal and stay within the law?
Yeah, so I often say to clients that if you think that you have an easy fix to address disparities in your workforce, you're doing it wrong. This is a long-term project that takes time and commitment and resources, and not about setting, okay, well, the next hiring that we're going to do is going to be a person who is X. That's when you get into trouble. So in terms of recruiting and hiring done correctly, it's going to focus on things like making sure that you've got a diverse set of resources in terms of where are you getting candidates from. Are you making sure you're not just doing recruiting by, for example, word of mouth, but that you're looking to diverse sources, that you're getting diverse pools of candidates, and you're also looking at issues like implicit bias, how those things are impacting the decision makers that you have. And I'm sure we'll talk a bit about DEI training as we go, but it takes a serious commitment, not just to sort of check a box with your decision makers to make sure that they understand those concepts, but make sure that you understand how it's playing out in recruiting. But it's really about spending the time and the resources to make sure that you're getting diverse groups of candidates rather than just feeling like you can quickly sort of address it by ticking a box.
Marty?
Yeah, there's been a huge focus, and I don't need not tell this group, huge focus right now on DEI initiatives, and specifically in the recruiting space, right? Because the feeling is, let's bring these folks in, and then let's retain them, and then let's see them, folks prosper within our organizations. There was a huge spike and uptick I saw with the client base that I work with, post-murder of George Floyd, post-summer of 2020, and the interplay between DE&I initiatives and ESG, right? The S silo, of course. And the emphasis and the interest by shareholder groups, investors, asking employers, what are you doing on DE&I in general, has resulted in employers, what I initially saw was rushing right in to implementing programs and initiatives without putting in place what I call the legal guardrails, right, to make sure that these programs are legally sound, because it's the worst thing, and I've seen this unfortunately with certain clients, to rush in, to put in a program that is blatantly counter to Title VII or any other myriad of laws, and then to have a discrimination lawsuit or something come up, and then for the internal naysayers who are against these initiatives from the get-go to say, aha, you see, we told you so, let's not do anything, right? And that's what we're up against from time to time. So, of course, in the recruiting space, we can never have a mandate, a quota, a thou must hire of a certain race or gender. But unfortunately, some employers are doing it, right? And David, you gave that example, whether it's in the academic setting, financial services, across the board, number of sectors. And there's some wonderful, teachable moments and teachable documents out there. And I'll cite to all of you, if you haven't seen it, public domain, the Weinberg versus Google YouTube case, where Weinberg was a person in recruiting, of all places. He was a recruiter himself. He was ultimately let go for valid reasons. He had performance issues, according to Google. And he turned around and filed a lawsuit for retaliation, alleging that his termination was actually a result of him complaining about the directives that he was getting from the head of recruiting that put in place essentially a mandate on hiring. And in the complaint, all in the public domain, I think it's in our materials you all can access, he included 2 or 3 emails from the head of recruiting to the recruiting team, and I'm going to quote, saying, beginning in Q3, we hire for 2018 all diverse, or only accept new candidates that are from historically underrepresented groups, right? And obviously, as we know, that creates a legal risk. So, what goes hand in hand with all of this, and we'll get to this during this discussion, is training, is making sure that all of the individuals, whether they're in human resources, hiring managers, or otherwise, have a thorough understanding of what are the applicable labor and employment laws in play, and that they don't run afoul of those laws.
So Pearl, when you look at these policies and with a slightly different lens, what are you seeing in terms of the hiring?
Okay, well, since I have a sneaking feeling that all of you didn't peruse our biographies with the expectation that we have, Michelle is an outside counsel at Kev McGuire.
And Margolis.
Okay.
That's it.
And Marty's a former Goldman Sachs in-house lawyer, and I generally represent employees. So this is NYU's idea of diversity. We're all white, we're all Caucasian, but we come from different segments of the
You're pretty old, too.
And I'm pretty old.
All of us.
No, I heard that, Marty. Okay. The one comment I have on hiring is, we were talking a lot about this, and of course, it's a laudable goal for employers to have an approach where they want a diverse workforce, where they want people of all different ethnicities, ages, abilities. But of course, as everyone said, they can't just decide that they need 2 more Black people here or there. So my only comment on the hiring is, it would be really helpful if employers weren't just looking at race, gender, ethnic groups, but looked at the totality of people. Because if what they're looking at is people who have different experiences in life, who come from maybe lower class groups, not just the legacy people at Harvard, but the kids who kind of clawed their way up from some small town in Texas, they can look at all sorts of different criteria that hopefully would allow people to achieve a diverse workforce, but do it in a way that wouldn't cause questions about legality later on.
So I want to move from kind of the hiring to what people, what we do when, with our current employees and our future employees and programs and so on. But Michelle, you talked about not just going to the same group or the same school and so on, and broadening the recruiting. And that's what we advise employers. From your experience, and Marty too, does it work? Is it like, if you're now expanding and looking, if you're taking people right out of college and you start looking at historically Black colleges, and if you don't just go with whatever the top 20 universities and start going to some of the state schools or directional state schools, as we call them, does that change anything? Have you seen it work, or is it without kind of saying, this is my mantra, I'm not getting there?
Well, you mentioned earlier the example of saying, your bonus or your compensation as a leader is going to be tied to, achieving sort of diversity goals in terms of outcomes. I have seen it done effectively where the mandate is, I need you to explain to management what were the resources that you went to. It's always easier if you've done hiring, right? It takes a lot of time. It's hard to prioritize it. It's always easier to say, hey, do you know anybody? Maybe you know someone. That's an easy way to hire, and that's an easy way to continue, sort of historical imbalances in your workforce. So that's what I said before, that it takes time and resources to be done properly. And so what I see clients doing, the mandates that I see them instituting is, when you're hiring for a position, I want to know what were the recruiting resources that you used. I want to know who you reached out to. I want to know who you reached out to, what schools you reached out to, for example, what organizations you reached out to, for example, to say I'm want to invite people to apply. And so that's where I see sort of the mandates coming in that are effective, is saying I want you to explain to me in a hiring memo or some other way that I'm going to track it. You need to justify your process and not necessarily have a particular outcome. And I have seen that be very effective, but it's not going to be a sudden change. It's going to be something that takes time to sort of bear out.
So look, this can't be a check the box exercise, right? And it can't be, again, something that the chief diversity officer or even the board is telling the C-suite, this is what we want you to do. It has to be organic and has to be bottoms up, and everyone has to understand the rules of engagement. So you take, for example, many organizations implementing a form of the Rooney Rule, right? If those of you not familiar, it comes from the National Football League, where there was a mandate that for any head coaching vacancy, at least one person of color had to be interviewed for a head coaching job, right? So then corporate America borrowed that and said for any slate of candidates, for any vacancy included in the slate, you need either one or two or a percentage of people of color, of women, or what have you. That's all well and good as long as it is being implemented and followed in a fair and a legitimate way, right? And you could read in today's Law 360 the update on the Wells Fargo case, for those of you who haven't followed that, where the allegations were this was implemented in a farcical fashion, right? Jobs were already filled, and because they had this Rooney Rule in place, women and people of color were being interviewed after the fact of a hire already being made, right? And now there's a shareholder derivative lawsuit being brought against Wells Fargo, amongst other things. So, these programs, again, are very important. They're laudable, but there needs to be education and training and understanding around it in order for them to work.
So, yeah. Just speak loud, what the hell?
I can do that. Hi, I'm Diana Pyle. I run a consulting company around DEI analytics, and a lot of what I do is I help companies set these goals and then measure and track their progress against it. One thing we talk about a lot is the difference between lagging and leading indicators. And the outcome of the hiring decision is how many people you hire that are diverse, quote unquote. That's a lagging indicator, not a leading one. So my question to you then, Professor Sherman especially, is what is the legality of metrics around the pipeline building, metrics around stuff that happens before that we're incentivized, before the hire is made?
When you're incentivizing what? I mean,
That you have to, at least, to the previous comment, interview X number of people. Maybe there's a process you need to follow with a structured interview, you need to see documentation of it. People that are screened in the resume stage, how many resumes did you look at that come from people of color versus white people? Stuff that happens before the decision is made.
Yeah.
I mean, I'll throw out a comment and see what you all say, but I think that, again, the standard is a really low standard. If it's a motivating factor, it's unlawful. And so if you're saying that we're going to look at these resumes and we're going to require this, require that, and that's motivating, it's problematic. I mean, what they talked about before was saying historically we looked at this set of schools, this set of whatever, and we got a group that looked the same. We're gonna cast the net broad. There's no issues with that. But when you start saying, I mean, even the Rooney Rule, I think can be problematic when somebody says, well, wait a second, you said you had to interview him, you didn't have to interview me, and now I didn't get a shot. And if you start looking at the cases from Title VII way back when it was a different concern, making it work at the end isn't a defense, right? Connecticut versus Teal. No, you can't fix it at the end. So if you
I think
I'm not saying you have to, the goal isn't interview people just because they look a certain way. The presumption is everyone you interview is qualified for the job, has the professional experience, has all the qualifications to do it and the ability to do it. Why is it wrong to allow
look, I think from a legal safe harbor perspective, and this borrows from the affirmative action jurisprudence, and for those of you who are federal contractors and have either affirmative action plans or you have a voluntary plan, you have to look to labor market availability, right? You have to do a mapping exercise to see, okay, I'm hiring for analysts in the technology division in the New York area. What is my relevant labor market availability? And then based on that, you set not targets and not mandates and not quotas, but you set aspirational goals, right? And you can.
I mean, but still, again, I mean, it's, you know, you asked the question, why? Because. You know, I mean, I'm not advocating, and I'm not saying that, you know, it's going that, because the law was made for a completely different purpose. The law was made to open opportunities, and and we'll get to it in a little bit about sort of a colorblind society that doesn't exist. And now we're applying it and we're shoehorning it, but it's still the law, and it's problematic.
What I want to know is why, if we're supposed to be hiring people based on their abilities, and this is before, most times, they still going to have an interview with you. So why are they making you send a picture? Okay? This is what is working against youth, women, and everybody else. I mean, what can you tell by a picture? Every picture tells a story. So they know who you are. I've actually seen ads that want telling you what you're supposed to look like, your breast measurements, everything for, you know, certain jobs.
Well, I mean,
That's illegal. So
well,
why
because
can't
that's
we do something?
well, that's going the
on
other.
basic jobs like working in Kmart or wherever? Why do they need a picture for the
That's-
interview?
That's
So
going.
they can automatically discriminate against.
Well, that's going the other way. You know, you're asking why people are doing things to discriminate. We're actually looking at those that are trying to diversify within the law. You're bringing up why are people still discriminating? Because, you know, I guess some
But
people.
they're using these
No,
tactics.
I'm not saying they don't, but, you know, I mean, I guess, you know, some employers still suck. I don't know what to say. You know, but, you know, I mean, but we're not looking at, I mean, that's not where we're talking about those that don't suck, but are trying to stay within the law.
This is Janice Chambers, Case New Holland. So my question is that some employers set aspiration goals of saying at management level they need say X percentage diverse talents, and at other levels, what are the issues with that? You know, in particular with reverse discrimination.
Well, they're not really issues as long as, again, those numbers are based on an analytical rigor looking at labor market availability. And I could see, again, there was a, you know, if you go back, you look at the newspapers in the August, September of 2020 timeframe, post-George Floyd murder, post-summer of 2020 events, and company after company where it's saying 20% of our workforce will be women by the end of this year. 40% will be black. You know, nice round numbers, what I call the pie in the sky numbers, right? And then you read the statement, and I'll pick on an old employer of mine, Goldman Sachs, saying 11% of our incoming analyst class will be black professionals, 14% will be Hispanic. You know, you can see, right, you know, these aren't round numbers, and they're not pie in the sky numbers, and you knew that they went through that analysis, and that gives you the, I think, the legal protection, and also it doesn't set you up to fail, right? If you're choosing numbers that you're never going to reach, then again you're just setting you know, programs back. Yeah, you want to aspire, and you want to maybe, you know, go a little bit higher than that, but that's how I think you do it.
And Marty, I would think that it should be, not will. Because what you're saying is,
Yep.
when we're doing this, and the qualified folks, the numbers should be right. So if it's 50% men, 50% women, that's what it should be. If it's 15% black, that's what it should be. And it's not will, must, we demand, but that's what it should be, and that's what our efforts are getting us there.
That's right. I agree with that.
Okay. Before we leave hiring, though, I'd like to say something is, Michelle and Marty were talking about recruiting and going to a variety of places. I think that one of the things we're trying to convey here is how complicated and how much thought needs to go into these programs if you want them to be successful. Because I think it's not only the factors that they've identified, but who your recruiters are and what are their prejudices, if any, what are their views about how and what the company needs, how are these jobs advertised or promoted online. There's a whole variety of things that need to be looked at, and I think that if it's done right, it's going to be very time-consuming, it's going to be expensive, but then it won't be the knee-jerk, we're going to hire more women in blacks. We're going to not only cast the net wide, but do it in a way that all elements of the recruitment and hiring procedure are scrutinized.
I think that, I mean, it's got to be right. Let's move from hiring to, a colleague of mine just did a study, found that folks who were part of the programs at a whole number of employers that had D&I programs, so the members that were participating were dissatisfied with them, that they just didn't think that they were matching the expectations. So I'm going to, start with Michelle and go to Marty then, and just say, what are you advising your clients to do after the hiring process?
So there's an appropriate focus now, not just on DE&I, but also belonging, DEI and belonging, because it is not enough. And again, this is what I'm talking about in terms of employers who think that there's sort of a quick fix, which is, okay, hiring, I'm all done now, see how I did this, and now I can turn my attention to other matters. But what we find in so many companies is what's missing is what happens next. The very point that you're raising, how do we retain employees? How do we make sure that the next steps are there in terms of what are we doing around mentorship? What are we doing around looking at our promotions? It's not enough to hire people, but we need to make sure that we're set up so that the environment is one that people can feel comfortable and can feel safe, and that we can retain those employees. So employers, again, do things like have employee resource groups. There's challenges to those because they have to be employee-driven, employee-led. I mentioned DE&I training before. Again, it's a good thing to do, but only if it's done right. I certainly have had claims as a management side attorney that have come out of things that have happened during those training sessions, because they're not well constructed, they're not well vetted, and they can end up, othering people, making some people sort of have to educate their peers, putting pressure on our employees to make other people feel better about their own prejudices, for example. So all of these things are things that take time and attention, and it's not enough to say, well, I've done my bit because I did the hiring process. And what we see in so many employers is it's still not a good space for people to be in, particularly if people are doing it because it's mandated and they're saying, okay, well, I'm done now, and there's nothing more for me to do. That's not the case whatsoever.
Yeah, again, all of these programs, all well and good, all very important. Let's make sure legal guardrails, though, are in place. So you take employee resource groups. There really should be guidelines around the ERGs. ERGs need to understand what their lane is, that they are not supplanting the role of human resources, that if they ask for data, they want to see the number of hires, they want to see how women versus men were compensated in the last cycle, they want to see data on promotions or hiring. Yes, within reason, but that's not their purview, right? ERGs are typically for raising awareness, for bringing together education, celebration of Heritage and History Months, and the like. Mentorship and sponsorship programs, all very important, but someone needs to be monitoring that, right? Are our white male sponsors only sponsoring other white men, or mentoring white men and the like? So we're just self-perpetuating the problems. Training, what I saw, again, post-2020, a cottage industry. Someone goes out and reads a book, on unconscious bias, and all of a sudden they become an unconscious bias trainer. And you bring them into your organization, and they create the problems that Michelle is talking about. Again, setting the program back years and years and years. So it's very important, particularly those of you in in-house counsel roles here, have an awareness of what's going on in the DEI space, and you know, or keep an eye on things so you're not creating more legal risk for yourselves.
Can we talk about, you brought up data, and I feel like you and I have had this conversation maybe 10 years ago.
Yeah.
About data sharing, activist shareholders asking for this data. Maybe, I'd be very interested in your views on it.
Yeah, the question is about data and you know, the requests from data, probably both internally and externally, and how do you come about, you know, with sound data. You know, this goes back a couple layers of how are you soliciting self-identification categories of your employees, right? You know, of course, EEO1 reporting, we have to do that for race and gender, but if you're using it for other purposes, and if you're including categories beyond race, gender, sexual orientation, disability, veteran, first-gen college, et cetera, which I've seen many clients do. You have to be very careful, of course, of what does that instruction form look like, and making sure you're not mixing your diversity efforts with your EEO1 instructions and the like. But Erica, I think with respect to the data itself, once you have it, you have to be very thoughtful about who gets to see it, how is it shared, in what form, and remember, anytime you're collecting data that you don't ordinarily have to, right, beyond your EEO1 categories, you're creating discoverable information. And certainly, if you are going to use that data to then run any kind of analytics on compensation studies, on termination studies, on promotion studies, all of that, full stop, needs to be done under legal privilege initially, lest you're creating risk for sure.
The other thing is I've been trying, in prep for this program, to find data on effectiveness of DEI programs that are designed for the people in the workforce. And I really can't find very much data on that, because there are so many different programs, there's so many different employers, there's so many different bases from which you could extrapolate something. If what you're asking for is data about comp and hiring, those are pretty objective numbers. If what you're looking for is data on the effectiveness of different kinds of programs that are disseminated to employees, if you find that, please let me know, because I've been looking very hard for it. And also, I think it would be a very challenging thing for any academic to study. Okay.
Thanks. So I'm gonna switch gears now and tee up. This is about the future, so I'm gonna make the proposal, and then I think I'm gonna get beat up a little bit. So I'm looking forward to that. So let me just give a little background, and this is sort of where I'm going on this proposal. I begin with Title VII is based on a theory, and again, it's Civil Rights Act of 1964. For those of us who were in school in the 60s and the 70s, remember the melting pot? We were all gonna, America, we're all coming together, and then in some amount of time, there's gonna be no differences. We're all gonna look the same. I mean, that's what I learned.
We're going to think the same.
Yeah, we're gonna look the same, think the same. Yeah, and so we're a melting pot, and so on. And so the theory of Title VII is all about equality. That if you took 100 of whatever protected class or non-protected class, threw them on the wall, that the same percentage would be smart, the same percentage wouldn't be smart, and have work ethic, wouldn't. That was it. Everything's the same. That's the theory. And then throughout time, customer preference. And this is a true story. I have this strong memory. It's 1974 dinner. My parents are both in like this crappy mood, and I don't really get it. I'm 10 years old. My father's freaked out. The stewardess on his flight was a guy. It's just wrong. And he's really upset. But my mother, can you top this? The gynecologist's office hired a female doctor. And she just didn't like it. And I'm like 10, what do I know? I'm like, all right. I tell that to my students, and they look at me like I have two heads. That was actually a thing. but we've got a lot of law on customer preference, right? Customer preference is not a defense to discrimination because it's going to perpetuate discrimination.
Well, you shouldn't use the word stewardess. You should use flight attendant.
No, I used stewardess because my father was speaking in 1974. I never used the term stewardess.
All right.
But I'm using his words, you know. Dad, you know, hey, sorry, man. Anyway, and so the point of that is that now we're going completely the other way. And now we're saying, I'm sure that some of the law firms out here have clients who demand that your firm be diverse. So now the customer preference isn't that the flight attendant be a woman and that the doc be a man. It's that there's diversity across the board. And we had a roundtable last fall in Ithaca, and one of the lawyers said, well, why can't diversity be a non-discriminatory business reason? And my response is, because it's not, and because Bostock goes on and on about Title VII is about the individual, so we need to change the law. So why can't we change the law? And why can't we say that, and this is the title of the article, that both Title VII and I are turning 60 next year, I've changed, can it? So why can't we make sort of a BFOQ type exception and say that that a defense to discrimination, because there's no such thing as reverse discrimination, it's just discrimination, a defense is diversity. And that's what, so when I had two candidates and I couldn't decide, or when I was looking and I said, you know, it's the Joe Biden theory. I'm gonna get a black woman to be Supreme Court Justice because there's 1,000 qualified people and some strong percentage are black women, and I'm gonna choose one of them. So why can't I do that for my general counsel? Why can't I do that to diversify, not to perpetuate discrimination? So that's the theory of my paper, and who wants to beat me up first?
I don't think I'm gonna beat you up, but I just wanted to add a little bit in terms of BFOQ, bona fide occupational qualification. It has been, as this group knows, very narrowly drawn. One example that I thought was interesting that came up for me recently was in the entertainment industry, there has been more and more of a push for authenticity in casting, right? And so that's coming from audiences, that's coming from employees, that's coming from sponsors, advertisers, and coming, in certain contexts, from donors. And it's sort of a play on that same theme, is that we want authenticity in casting. And this came up, you may have seen there was sort of a dust-up around the casting for the musical Hamilton. Because, and this is going back a number of years now, because the casting notice explicitly said, we want non-white performers. And what you typically see in casting notices is it focuses on the character is a woman of this race, this is her occupation, this is her age, and they're looking for somebody who can convincingly play that role. You don't have to be any of those things. You have to be able to convincingly play that role. That's why 30-year-olds play high school students, because they can convincingly play the role. But the producers of Hamilton really pushed back on that and said, no, I said what I said, and these are the people that we are looking for, and with the exception of King George, we want all non-white performers. And there was some dust up around it. And Actors Equity actually came out and said, no, we disagree, and the casting notice for Hamilton is not in line with what our expectations are. And the sort of producers sort of quietly revised the casting notice. It didn't change the outcome in terms of the casting, but they sort of quietly changed what it said. But that's a way in which BFOQ just sort of evidences that BFOQ is pretty narrowly drawn, because where you would think about it right now, certainly applying, would be in the entertainment industry, models, actors. Those are the kinds of contexts we typically think about now, and that's just sort of adding that BFOQ context a little bit.
Yeah, and BFOQ gets even more difficult than the casting because race and color don't count.
Correct.
There is no BFOQ for that, so then you're dancing the whole Othello problem, so that gets even worse. And BFOQ has been so narrow, and so what I'm proposing is something that it would be an affirmative defense type of thing, but it wouldn't be so narrow, and it would be, you know, it would be in a defense to, you didn't hire me because you wanted diversity, or you didn't hire me because I'm white, and that's right, I didn't hire you because you're white, because I wanted diversity, and here's why, and that would fit into some sort of exception. Marty's kind of rolling his
Well,
eyes, so
I
go
think this is the classic, the exception is going to swallow the rule, right? The exception is going to thwart Title VII entirely, and it's also
Wait a
using.
second. I'm sorry, because, so what you're thinking is that white guys will never get hired again? I'm not worried.
I'm not worried either, but it's also, and I'm sure we'll hear about this in the next panel or two, talking about the Supreme Court cases in the education context. You know, how, you know, it's using race or gender or any other category as a proxy, and you can use the hypo of the white kid who grew up on the farm in Nebraska at the poverty level versus a Hispanic African American who grew up in upper crust Greenwich, Connecticut, went to boarding school, sure, there are life experiences that, you know, both of them are going to have, but at the same time, what are we really trying to achieve? And I think in the education context, by the way, you're going to see more in the applications talking about, you know, how did my life experiences color who I am versus, you know, who I am based on my race or gender or otherwise.
I'm just going to push back a little on the swallowing the rule. I think that's why in '64 they didn't, on the BFLQ, why race and color were not included, because the fear of it swallowing the rule, because you were trying to get rid of this level of discrimination. But to your point, if the company finds that the Hispanic kid who grew up in Greenwich, who's the child of a Goldman partner and a Skadden partner, isn't diverse, and the kid who grew up in the farm and, you know, went to school after milking the cows is, no one's gonna, there's no case there, because that's not the issue. It would be if they decided between the white kid and the black kid that they want diversity, that would be their affirmative defense to show. There's no law against them hiring the white kid unless they hired the white kid because they didn't want to hire the black kid. So I don't see the swallowing of the rule. I see other problems. I'm not saying it's not problematic, but I don't see the swallowing of the rule. Michelle, got a...
Yeah, I was just going to say, and then the first time that the case is about how we needed to diversify nursing, for example, or any other profession that might be, for example, dominated by women, and that means that now we need to be hiring more men into those. Then you see sort of the unintended consequences and things that maybe we don't feel so comfortable with comes up.
Well, what I'm wondering about is if there's if we have a hypothetical black male being hired and a white male challenges it, an affirmative defense, if your theory goes through, is that they need diversity, but how much is that weighted? I mean, if you say you want a diverse workforce and you hire a diverse person who might have a different educational level, a different experience level, it can't be just on diversity. And I would think that trying to defend against it, if you're saying you were seeking diversity, and then having all these other factors that someone could challenge it on, how is that going to be a viable affirmative defense?
I mean, I think I'd go...
Zach agrees with me, so, so that's
Yeah,
good.
and he totally disagrees with me, so, you know, so yeah, right, we haven't agreed in years. But, yeah, I mean, I guess I'm going with what we've developed law, minimally qualified. You know, so if I'm the employer and I decide that, you know, these folks are qualified and now I'm making a decision, I mean, I generally don't think employers like paying people who can't do the job. I mean, that's a general rule, like it's a bad idea. So they want somebody who can perform, and if they're saying, I think this person can perform and this person can perform also, and I want a more diverse workforce because that's what my clients demand, that's what my customers demand. I think it's the logical extension of what we started in '64 to get to where we want to be, because we've now accepted people aren't all the same. They bring different things to the table, and we want to bring that in now we have to sidestep the law instead of having the law embrace it.
So I'm just confused. Are you saying we should change BFOQ and/or customer preference? Because you seem to have
well,
been melding two.
Yeah, I'm saying that a BFOQ-esque defense to say that diversity is a legitimate business reason, and that customer preference demanding diversity is not the negative that that my mother and father's customer preference, that they were perpetuating discrimination. That's a problem. Customer preference that is asking for diversity is something that as a society we should welcome. Zach?
You know, I've always thought that the right approach to all of this is the OLCCP approach, which is, and that's what Marty was talking about too, which is you get a large enough pool, you try to get diverse candidates every year. At the end of the year, you gauge your efforts to decide whether that was a good faith effort or not. And then you reset your goals. You're not guilty of violating the executive order. You don't get your contracts lifted at that point, but you go and you gauge for the future. I mean, why isn't that a logical approach to this entire area? Without going into customer preference, I started practicing even before you did, and the customer preference stuff that I confronted was unbelievable. So I'm a little leery of going down that route at all.
My only concern with going that way is we're kind of taking the affirmative action approach, which is required. And I'm not proposing that this be required. I'm proposing that this be allowed. So that's, you know, I don't have a problem with the way you're looking at it, but I don't think that we want to require it, but we can allow it.
But isn't the answer to that what Pearl said too, which is everybody brings a different qualification, and where you want to set the qualifications depends in part upon diversity and in part upon what you're looking for. I mean, you want somebody who can use a sports analogy, you want somebody who can shoot a better hook shot or a jump shot, or you want someone who can write better, who can teach better. I mean, there are all kinds of qualifications, and there's plenty of slippage in those joints as long as you don't make it a rigid approach. I've always thought that that's the sensible way around this.
Yeah, it's one factor, Zach, right? I mean, you're looking at various factors, and that's a factor that can be considered, absolutely. And, you know, I think the problem is many employers don't want to make that extra effort, right? And look, the CEO of, not to pick on them again, but I will, this was in the public domain, the CEO of Wells Fargo famously on congressional testimony said we'd hire more blacks, but they're just not out there, right? And he was called to task appropriately for that because, right, they are out there. You have to go out there and do, you know, do your work for it.
And I'll go with the other CEO comment that I heard, which was when we were talking about D&I and this person was talking about goals. I raised my hand and I said, that's unlawful. And the response was, bring it. Fine. This is the right thing to do. I'm going to do it. And if somebody wants to sue me for it, that's fine. You know, I'll defend that lawsuit. And my take on it was, wow, that's really interesting and pretty gutsy. But I would like the law to allow it instead of having someone stand up there and say it's the right thing to do even though it's unlawful. Like, why do we have a law that prohibits what we think is right? So I think we're done.
Are we over? I was just going to ask you a question, really.
Davida.
Oh, okay.
Okay. I was just going to sort of ask you a question about your proposal, because some of this is already happening. So it depends on the role. So if you're looking at, just to go back to this sort of entertainment example, if you're looking at a writer's room, having diverse voices in a writer's room is something that everybody is looking for, and there can be really no legitimate question that it adds to the work product, right? But it sounds like what you're suggesting is that regardless of the position, so if it's widget makers, that diversity is a laudable goal all on its own, even though I can't really point to how it's sort of, you know, bringing something tangible. You're saying any position making widgets, that should be a defense.
Yeah, I think that I mean, I think that the widget manufacturer would tell you that, you know, that they still make decisions, they still operate, they still deal interpersonally with each other, and having a diverse workforce helps that. You know, it's not as tangible as the writers or the advertisers trying to do that, but I think that all business, they work in teams, they do things, and they still are trying to reach some customer base somewhere, and that having folks with different ways of looking at things is positive. So I think you can bring it across the board, even if it's not as down the middle as yours.
And tied to something tangible in the sense of you're not just picking a number out of the sky, but you're looking at, for example, you know, what market data and that sort of thing to say this is why I picked this particular diversity goal.
Yeah, and I'm not even saying that it need be a defined goal. It can be, you know, as we were saying before, that if you and I were up for general counsel, then the realization that I haven't really worked in 30 years, so that's not good. So let you know, you and Marty up for general counsel, and they decide that the C-suite is all men. They don't have a goal, but they're looking and saying both incredibly qualified people. Why can't they look and say we want to diversify the C-suite because we've got 2 qualified people and it's a all-male C, so let's change. And I would say that can be, that under this proposal, that would be a defense. Pearl's shaking her head.
Well, no, what I'm concerned
too.
is about unintended consequences, and it's pitting minority groups against each other. For example, if you decide that you need a diverse C-suite, you hire a black man, a white woman would say, why isn't she the diverse candidate that you want? Or why isn't it a Hispanic candidate? I mean, it has the potential. It's like the white male is the norm, and the diverse people have to fight for the slots that are presumed to be diverse slots. I think that's how it could be perceived, and I think it's how it could fall out.
I mean, I can't say no. You know, I mean, I hope that it's not, and I hope that we can play it out better. But I mean, if the 2 choices are, it'll be perceived as, you know, these slots only, or status quo, which means the only way to get diversity is to say, bring it. I know I'm violating the law. I'd rather deal with the unintended consequences than deal with something that what the law prohibits, what is both good and what employers want to do. And we're saying, no, you can't do it because we're stuck in a 1964 belief that we're all equal and we're melting and all that stuff.
Well, as I said, I think it could have some very pernicious unintended consequences.
Yeah, no,
Because I talk to employees, you talk to students and academics. And
so cold.
And I'm here to tell you that I talk to a lot of people who go through these diversity programs in things that are separate and apart when they come to talk to me about getting a new contract for a new job or whatever. The reaction is often extremely hostile to what's going on, about how they're made to feel as if they're the problem, that other people are getting preferences for no good reason. I think that the big issue is that they're not spending the time, the effort, the all-inclusive approach to make sure diversity works.
Right.
Questions, comments?
No,
Last word, Marty?
last word. It just can't be a check-the-box exercise, as I said
Right.
earlier. It has to be holistic. And stay tuned, right? Because whether it's Starbucks or Mars or Anheuser-Busch, we're just seeing now the backlash, right? The litigation being brought against these organizations who are trying to do the right thing. And you know, it's, you know, white male replacement theory, and we could do a whole program just on that topic too. But there is the pendulum here, and stay tuned for that.
And now it's officially our time. So thank you all.
Rita.
Thank you.